Welcome back to Law Shield Advocates. Before we break down today's major constitutional update, make sure to subscribe and check the links below for our continuous coverage.
लॉ शील्ड एडवोकेट्स में स्वागत है। चलिए, कर्नाटक स्कूलों के इस ऐतिहासिक और बड़े फैसले की पूरी डिटेल समझते हैं।
आज की ब्रेकिंग न्यूज समझने के लिए जानना बेहद जरूरी है, आखिर 2022 से अब तक क्या बदल गया है। 13 मई को कर्नाटक सरकार ने अपने विवादित फरवरी 2022 के यूनिफॉर्म आदेश को पूरी तरह से वापस ले लिया।
थोड़ा पीछे चलते हैं। 5 फरवरी 2022 को एक सख्त यूनिफॉर्म नियम आया, जिससे देश भर में भारी प्रदर्शन हुए। फिर मार्च 2022 में हाई कोर्ट ने बैन सही ठहराया, जिसके बाद सुप्रीम कोर्ट का फैसला भी पूरी तरह बंटा रहा। असल में CET 2025 में पवित्र धागा पहनने से जुड़ी एक जनहित याचिका ने इस मुद्दे को फिर गरमा दिया। अब फरवरी 2022 की उन सख्त पाबंदियों की जगह स्कूलों में एक नया और काफी समावेशी दृष्टिकोण अपनाया गया है।
तो अब सबसे बड़ा सवाल उठता है, आखिर क्लासरूम में किन पारंपरिक और धार्मिक प्रतीकों की इजाजत दी गई है।
नया नियम से छात्र यूनिफॉर्म के साथ हिजाब, पगड़ी, जनेऊ, शिवधारा और रुद्राक्ष जैसी चीजें अब बेझिझक पहन सकते हैं। लेकिन ध्यान रहे, इन प्रतीकों से स्कूल के अनुशासन, सुरक्षा या छात्र की पहचान में कोई रुकावट नहीं आनी चाहिए।
संस्थानों को सख्त निर्देश है कि किसी भी छात्र को ये प्रतीक हटाने के लिए बिल्कुल मजबूर नहीं किया जाएगा।
हालांकि एक अपवाद है, राष्ट्रीय और राज्य स्तर की परीक्षाओं में अधिकारी अपना ड्रेस कोड लागू कर सकते हैं।
ये नया आदेश धर्मनिरपेक्षता को दोबारा परिभाषित करता है, जो मान्यताओं का विरोध नहीं बल्कि समान सम्मान सुनिश्चित करता है।
सरकार ने इस फैसले को 12वीं सदी के समाज सुधारक बसवन्ना के दर्शन वे हमारे हैं पर आधारित किया है।
क्या ये नियम अनुशासन और विश्वास में संतुलन बनाएगा? ऐसी ही अपडेट्स के लिए लॉ शील्ड एडवोकेट्स को सब्सक्राइब करें।
On Wednesday, May 13th, the Karnataka state government issued an official circular effectively revoking the controversial 2022 hijab ban order. This directive was issued by the School Education and Literacy Department. Under the new rules, students are explicitly permitted to wear traditional and religious symbols in schools. The order specifically mentions the Islamic hijab and the Sikh turban, or pate, as permitted items. It also includes Hindu symbols, such as the sacred thread, the Shivadara, and the Rudraksha. These symbols must be worn alongside the institution's prescribed school uniform, rather than replacing it. By issuing this order, the state executive has bypassed a deadlocked Supreme Court to address an educational access crisis on the ground. This creates a direct legal tension. The state government has altered policy, while the underlying constitutional question remains in judicial stasis. The 2026 framework permits religious symbols previously barred under the 2022 requirement for strict uniformity. To authorize this change, the new order relies on the Karnataka Education Act of 1983. Specifically, the state cites Rule 11 of the 1995 rules to define institutional dress code limits. While this executive power changes state-level school administration, it does not resolve the national constitutional dispute. Article 25 of the Indian Constitution, guaranteeing the freedom of religion, remains the central unresolved issue. To understand how the government found the statutory latitude for this order, we must look at the timeline of the 2022 ban and the subsequent judicial gridlock. The crisis began with a government order issued on February 5, 2022. This mandate applied to government, state-aided, and private schools, as well as pre-university colleges. The 2022 order directed these institutions to strictly enforce their prescribed uniforms. In practice, this enforcement barred hijabs and all other visible religious symbols from the classroom. The reaction was immediate, with protests spreading across Karnataka and gaining national attention. These demonstrations quickly led to a series of formal legal challenges. Petitioners argued the ban violated their right to religious freedom under Article 25. They claimed the ban forced students to choose between their faith and their access to education. These initial petitions brought the entire matter directly before the Karnataka High Court. The 2022 mandate had turned a dress code dispute into a test of state power over personal religious practice. In March of 2022, the Karnataka High Court delivered its official ruling. The court upheld the state's uniform mandate as legally valid. The decision rested on the essential religious practice test. This doctrine determines whether a practice is a core, mandatory tenet of a religion, qualifying it for constitutional protection. The High Court ruled that wearing a hijab is not an essential part of Islamic faith. Because the practice failed this test, it did not receive the absolute protection of Article 25. The petitioners immediately appealed the decision to the Supreme Court of India. A two-judge bench heard the case to review the legality of the 2022 circular. The two judges delivered a split verdict, failing to reach a consensus. Procedurally, this deadlock meant the case was referred to a larger bench for final determination. That review remains pending before a larger bench today. This judicial stalemate left the 2022 ban active, creating a legal gap that eventually led to the current executive intervention. The state was recently forced to act by a public interest litigation regarding the Common Entrance Test for 2025. In that case, students were reportedly barred from exams for wearing a sacred thread. The High Court's inquiry into this PIL highlighted how the 2022 ban was creating friction across multiple religious communities. The government responded by issuing new circulars that redefine the rules of accommodation. The new May 13th order permits religious symbols, provided they meet three specific operational conditions. First, the symbols must not interfere with institutional discipline. Second, they must not pose physical safety hazards. Finally, the symbols must not prevent authorities from clearly identifying the student. The 2026 circular relies on the Karnataka Education Act of 1983, utilizing the same legislation that underpinned the 2022 ban to now authorize religious symbols. The order issues strict directives to school heads and governing bodies regarding student treatment. Authorities are prohibited from denying admission or excluding students from academic activities because they are wearing permitted symbols. No student can be forced to remove these items, and the order explicitly bans derogatory treatment of those wearing them. There is one limited exception: examination environments. For state or national exams, authorities may still enforce more restrictive dress codes. This exception is designed to maintain standardized security and prevent cheating during high-stakes tests. The policy attempts to provide daily religious accommodation while preserving security during testing. The government's order describes secularism as a tool for institutional fairness and equal treatment, rather than an opposition to personal belief. The preamble cites the 12th century social reformer Basavana to support this view. It quotes his principle, Eva Namave, meaning they are ours, to encourage institutional empathy. Despite this shift in policy, the final legal status of the hijab under Article 25 remains undecided in the Supreme Court. Until the Supreme Court issues a final ruling, the Karnataka executive has used statutory authority to restore educational access for students across the state. Thank you for watching. Subscribe for more in-depth legal analysis and follow the links in the description for our latest updates.